We immediately dive into the discussions on the fourth panel, which is titled Beyond Slander, Competing or Intersecting Challenges. And here, after we have spent the better part of this day looking at issues on the basis of the level of success our project had, bigger success stories, more mitigated results, and real challenges in the last jurisdictions we talked about. Now on this panel we try to approach things from a different angle. All the problems tackled in the context of this panel are not as wide as some of the problems previously referred to. So none of these problems have the magnitude or the repetitiveness of the SLAPS problem or the deepness of the connection of the problems with democratic institutions and the rule of law, with the exception of Hungary, of course. Here, what we rather try to do is to group together these more, still not isolated, but more emerging trends in the court's case law that demonstrate problems that are not novel, they are not new problems, but it is problems that they build up as bad students teach less bad students and making them worse. That's one part of the problematics we are going to talk about. We are going to talk about interesting cases of the court touching upon lack of media pluralism, which is the Italian example. We will also talk about, now it's the time to talk about free speech of judges in respect of at least the jurisdictions of Hungary and Bulgaria. And of course, we will also touch upon the very interesting situations of competing values and rights. So in those cases that the court has had to perform some kind of a balancing exercise, Article 10 against some other article or some other values, what did the court say in those cases has an impact, as we will see, on the solutions the states are ready to go into to respond to those problems. And I think it's important to have a discussion on all that. We will give the floor first to our colleagues online in Italy, our dear friends in Italy, Camilla Prunastola and Federico Ciamurati, both lawyers in Strali for strategic litigation. They have both been involved also from the very first stages of the project with us. They followed us also in Leipzig. We're sorry we could not have them here with us today, but we're grateful that they intervene online, because Strali, with the support, of course, of CHILD, the umbrella organization for the protection of human rights in Italy, and our also members of EIN and great collaborators in this project, they developed very important project activities in cases that we will see, but I will leave the floor to them to explore how the Italian cases do not reflect the magnitude of the problem in Italy in respect of free speech, I think, but still raise some interesting questions, both about how we tackle the existing situation and how we further our work on these matters. Camilla and Fede, welcome. Thank you for being with us online, and the floor is yours.
Okay. Thank you very much, Giulietta. Thank you to everybody. And we are very happy that we were invited to participate also today, because we were already in Leipzig from the beginning. And unfortunately, we couldn't make it to Greece. So thank you to all of you, and also thank you to EIN in general for organizing this very interesting project, and also to the supporters, of course. As Giulietta said, I represent Strali, which is an NGO that was founded in Italy in 2018. Our main, we are first of our kind in Italy, so our main purpose is to do strategic litigation. And one of the best ways to do it is to monitor the implementation of the decisions of the International Court of European Rights. Also, of course, to the help of organizations like EIN who highlight and give us the decision to monitor. So as you know, winning a case in Strasbourg is only part of the battle. So implementation remains a critical and often overlooked front. We are going to bring here our experience in Italy because we worked together with SHIELD, the other NGO from Italy, and we submitted 2 different Rule 9 communications. However, it was very difficult to see them translate into a concrete systemic change. So so despite our efforts, so we submitted the communication following, as we all learned, the right timing, right contents, in the sense of not being, in the sense of taking in translations official Italian documents, so to make the Committee of Ministers aware of the situation here in Italy. But we didn't receive a proper reply from the national authorities. So despite our efforts to engage constructively with the authorities, both submissions were met with silence. So this lack of response in Italy, especially in nowadays, welcoming. It reveals that there is a deeper institutional reluctance to engage with civil society and to fully embrace the democratic potential of Strasbourg jurisprudence. Before submitting these decisions, we also organized a roundtable in Rome together with SHIELD, and we met important stakeholders in order to try before to make people sensitive about the issues contained into these 2 Rule 9s of the decision of the court that needed to be implemented, and in order also to try to construct a dialogue to get then to the parliament. Today we are reflecting more, because I will leave the floor to Federico in order to go and examine exactly one of the 2 decisions. What we realized today is that the situation suggests that a more sustained and coordinated effort may be necessary to monitor the implementation process. In particular, we understood that maybe also only us and SHIELD as 2 voices are not enough. It may be useful to ensure that at least 1 Rule 9 communication is submitted each year for a single decision, and not only to maintain pressure on national authorities, but also to provide the Committee of Ministers with updated evidence-based information of the state of compliance. At the same time, we believe it would be strategically beneficial to bring together multiple NGOs from the same country when submitting Rule 9 communications. A collective voice, in our opinion, especially one that represents a broad spectrum of national civil society, can carry greater weight and visibility. It can also reinforce the idea that implementation is not a technical or bureaucratic exercise, but a matter of democratic accountability and public interest. What we can say right now is that we envisage some key measures for effective implementation in Italy, and we hope in the future, or with these Rule 9 submissions, even though we didn't have quick response we put together these goals. So it would be nice, it will be hopefully to have a clear and broad definition of SLAPs. So this we don't have in Italy. And then we would like that there will be introduced early dismissal procedures with specific criteria for identifying unfounded claims brought in response to public participation. We would like to achieve the introduction of dissuasive sanctions for claimants, such as cost-shifting rules, compensatory damages, and reputational consequences, which are essential to deter abuse. And then we would like to have financial and procedural support for defendants, including access to legal aid and fast-track mechanisms to reduce legal and psychological burdens. And of course, we hope for, we would like to achieve a greater transparency and monitoring, including perhaps a registry of defamations and SLAP cases. So this was a little bit a general panorama of the situation in Italy. I will pass the floor to Federico, so he will go into the detail of what actually was the content of one of our two Rule 9 communications. Thank you very much.
Good afternoon, everybody. And I join Camilla in thanking you, Giulietta, and on EYN team for inviting us today. And thank you again for your efforts and commitment in this very interesting project. I will go very quickly through the case on media pluralism that we dealt with. The case before the European Court of Human Justice was the Associazione Politica Nazionale Lista Marco Pannella against Italy, and the case originated from a petition filed by this association, which was a political movement active in Italy, against RAI, the state TV. The reason of the petition was that the association complained about the imbalance of space television granted to this association to communicate and to represent their political initiatives and program. And with particular reference to news program broadcasted by the state TV. The petition was filed before the Agcom, which is the independent authority for telecommunications in Italy, that in 2 occasions rejected the complaint. So the association appealed the decision before the administrative courts, which, put it in simply, declared that actually the association had the right to be granted more space on public TV and was illegitimately marginalized in the public debate. So the Agcom had to order RAI to take remedy in this regard. And actually, the remedy was partial because some news programs had been closed in the meantime. So the association basically considered the remedy by the state TV not sufficient for their for the restoration or their claim. The case before the European Court of Human Rights was concluded with the court decision that established that Italy actually violated Article 10 of the Convention, as the association was marginalized from the political media debate. And the reasons for which the Agcom decided against the association claim were considered by the court as too formalistic, as the association was not considered a proper political party that was allowed to have the same space in public TV as other political parties. And so basically treated cases differently and moved away from its practice. And the court in particular considered this in terms of imbalance and influence from the state in the public and political debate. And so established the violation of Article 10. As Camilla said before, we work on this case and together with the EIN, we prepared and submitted a Route 9 submission before the Committee of Ministers, by which we, of course, gave the general background of the different laws regulating public TV and communication in Italy, and we focused, of course, on the lack of implementation of this decision by the Italian authorities, and requested the Committee of Ministers to monitor the implementation of this decision, and to request the government to present an action plan on the measures that are planned to be taken by the Italian government to implement the decision of the court. I would like to mention also that there is an important public debate in Italy regarding the reform of the governance of the public television, because just to give you a very brief sense of the rules, governance is strictly related to and is strictly connected to political parties, because there is a governance body and a parliamentary commission that basically reflect the political parties and the political party with majority in parliament. So basically, it's strictly connected with political influences, and so there are many instances of reform of the governance of public TV in this regard. In view of submitting our Rule 9 submission, as Camilla mentioned, we also organized an event in Rome in May last year, where we involved different NGOs and associations from civil society to discuss about this topic. And we also had a very useful contribution by the Order of the Journalists regarding these issues, as other SLAP examples they experience. So, of course, as Camilla said, we haven't received a response now about the agenda of the Committee of Ministers regarding this case, and any replies from the government. So hopefully we will receive that, and so our work on this case will of course continue, and we are committed to do so. But this experience was fundamental for us, for our organization, for our NGO, to take part in this process, to be active in this activity, in monitoring the implementation of European Court of Human Rights principle by the Italian government, and we realized how central can be the role of NGOs in this kind of processes, and also the fundamental support by private actors and actors from civil society. So this is more all from my side. I don't know if Camilla want to add something else.
We can pass the floor to the next speaker, and thank you very much.
Thank you.
Thank you. Do you have time to take a brief question from me, Camilla and Fede? I know you have to go and we will not have you with us, but if you still have 2 minutes, I have one question which goes to the level of engagement of Italian authorities with the implementation mechanism, which is completely disproportionate with the magnitude of the problem in Italy. So Italy, as per our research, ranks as one of the worst pupils on implementation matters. But the authorities' engagement and response is very sparse compared to the magnitude of the problem. So I'm wondering if whether very soon we would need to count Italy among the countries that were involved in the previous panel. The only thing that's still separating them being the fact that the same repressive measures against journalists, civil society, actors, etc., are not present in the same intensity as with those most problematic jurisdictions, but in terms of response, I think the responses are minimal. And then what can we do to also increase the engagement of civil society with those matters? Because I have said again how we value very much, extremely, the cooperation with you and CHILD, because you really support our implementation efforts at national level. But otherwise, we are struggling to generate this response from civil society in Italy. Would you have in 2 lines some basic insight and input on those 2 matters? Thank you.
So, Giulietta, I have to say we can't hear you that well. I mean, your voice is up and down. I think I understood the question of maybe how what would be, given the distance that and not the lack of dialogue between authorities and civil society, which would be our suggestions? Is it correct?
First of all, how can we respond to the lack of responses of the authorities to the Committee of Ministers, rather, the lack of interaction with the Committee of Ministers, the meaningful interaction, which makes Italy rank amongst the worst interlocutors? And then how can civil society in general play a more active role in supporting this effort? Because you have been great in this effort, but you are rather rare examples in Italy of such support.
Okay, so for what concerns the first question, in our opinion, is that the lack of response is due also by, I think, the poor knowledge of civil society about this tool, and also a bit about this procedure that follows the ruling. So the implementation procedure. I think one answer could be this one. So in also among NGOs, I don't think that it is so well known, this tool. So I think that as we said before, if we manage to use AIM's job in identifying all the decisions that have not been implemented yet, so the role that you are playing, and then for these decisions try to submit constantly Rule 9 communications, not only to put some pressure on the court, but also to do a bit of advocacy about this submission of Rule 9s and trying to get more involved the civil societies with us. And of course, among civil society, there are NGOs who are more connected straight to the authorities. And then, of course, is about advocacy, I would say, Federico.
Yes, I agree, and I think it's fundamental that civil society and NGOs work a lot also on a national level. So that they can play a part, for example, inside parliamentary commissions, or because if the main object, I mean, measures that governments can take in this case in particular, is related to the adoption of laws and reforms about how public TV is governed, is that fundamental that civil society can have a voice, can play a part in the internal legislative process, of course. So there is room to improve also in this regard, in my opinion.
Thank you very much to both. We will release you now because you have other very important work to go on to. We remain in touch, and we thank you very much for your engagement with these cases, your national efforts, the advocacy event you organized, and of course all your work on Rule 9 submissions. Thank you very much, guys, and all the best.
Thank you. Thank you very much.
And bye to everybody. Thank you.
After having heard about lack of media pluralism in a jurisdiction that generates a lot of problems, and perhaps a question that a larger question we can discuss tomorrow is how we can better our game, our litigation game, because it is obvious that compared to the magnitude of the problem in Italy, we don't have enough court judgments demonstrating the problems or identifying the problems as clearly. So there's definitely work to do there. But moving on to the different subject now, as we announced, the question about free speech of judges. Very many jurisdictions have this problem. Some of our colleagues that participated in our other panels from Romania, from Poland, have been dealing with those matters in those countries. But it is also very important emerging trends in some countries like Bulgaria, or long-standing problems in other jurisdictions like Hungary, and we will see how aspects of this problematic now starts affecting Slovakia as well. We will begin with Radoslav Stoyanov, co-chair of the Bulgarian Helsinki Committee. You hold an LLM degree, and you're a long-standing human rights activist specializing in issues of discrimination, hate crimes, and LGBTI equality. You have been part of the Bulgarian Helsinki Committee since 2013 and assumed the role of co-chair last year. You also serve as co-chair of the LGBTI Dejstvi Association since 2025. Thank you very much. The floor is yours to talk to us about Miroslava Todorova.
Thank you so much. I will just start with a little bit of context. In the early 2000s, the issues with Bulgarian judiciary, or the focus of the issues of Bulgarian judiciary, was the chief prosecutor and an allegation against the then chief prosecutor of ordering the murder of a colleague of his. Which is pretty exotic, but yes, this happened. This was the first period of the need of judicial reform, the talks about judicial reform in Bulgaria. The next period was where Miroslava Todorova showed up, and this was the time when, from prosecutor's office, the issues transferred slowly to judiciary, where limiting freedom of expression of judges started to happen, and the current period is now that it's very clear that the judicial system has been hijacked. More specifically, as we heard, for example, I think from Georgia, that the Supreme Judicial Council is basically a captured body and is no longer able to properly administrate the judicial system. So, I mean, maybe I can use this.
It's a PDF, so you want the
Can you make it full screen, I think? No? Okay. Okay. I will tell you. So I will start with a brief presentation of the case. This is Judge Miroslava Todorova. At the time that the case emerged, she was not only a criminal judge in the Sofia Sofia City Court, which is a district court, meaning second instance criminal court, hearing criminal matters, but also she was an outspoken defender of judiciary, of independence of judiciary, criticizing the government. She was chair of the Union of Judges in Bulgaria, and she was a very prominent critic of, maybe next slide. She was also a very prominent critic of both executive and executive branch in the face of Ministry of Interior and the Supreme Judicial Council itself. So what happened around that time, which is 2011-2012, next slide, is that she was subjected to several disciplinary proceedings because many judges in the Sofia City Court had cases that they did not deliver the judgments of in time. And she was among those judges. Actually, she was the champion of number of cases that were delayed. So it was certainly true that she had many cases delayed, but it was also true that she was overwhelmed. She was the judge that had most cases assigned to her. The excessive caseload made it basically impossible for her to deliver judgments in time, quality of judgment, quality judgments. At the time, exactly at the time, basically a month after she made a very public criticism against the Minister of Interior for his public allegations that judges were involved in defending criminals, that the police is doing their job and they're arresting the criminals, but it is the judges who led them back to the streets, etc., etc. A month after she addressed this in her capacity as chair of the Bulgarian Union of Judges, several disciplinary cases were brought against her, one after the other. And they were all connected to the fact that she had cases delayed. So it was basically a research, how many cases are delayed in the court. So many judges were actually found to be in delay of cases, but she was singled out, definitely. So what happened is that she was sanctioned. First of all, her salary was cut with 15%. This is the next slide. Yeah. First of all, her salary was cut with 15% for 2 years. And then, by decision of the Supreme Judicial Council, I'm not getting into the details, but both Supreme Judicial Council and the presidents of the different courts can impose, can initiate disciplinary proceeding, can impose sanctions depending on the scale of the violation. So, by decision of the Supreme Judicial Council, she was also dismissed. Her dismissal was overturned as disproportionate by the Supreme Administrative Court, but nevertheless, she got demoted for 2 years, and that lasted until 2017. So in 2021, the European Court of Human Rights delivered a judgment finding violation of Article 10, among others, because the court more specifically, next slide, the court more specifically found that the chain of events and the severity of the punishment imposed on Miroslava Tudorova were linked to her public position. Furthermore, the court said, yes, the sanctions pursued a legitimate aim, and this is the ensuring of a proper function of the criminal justice system with the view of guaranteeing the authority of the judiciary. However, these sanctions were related to her public positions, and the court attached particular importance to her functions as chair of the Supreme Union of the Union of Judges at the time. And the court found that it was her role to defend judges. It was expected from her to actually do that. And that her positions were part of a broader public discussions on public matters, hence she was having high level of protection of her freedom of expression. And the sanctions against her had chilling effect, not only for her, but also other judges. What the court have noticed is that the Supreme Administrative Court, in delivering their judgment, they omitted completely the discussion of her role as a chair of the Bulgarian Judges Union, and that the interference of her freedom of expression was not necessarily in Bulgarian society. Next slide. So what happened on level of execution of judgment? In 2022, a year after the European Court of Human Rights judgment, the government asked for closing of the examination. And the reasoning for this was that they paid compensation for the costs and expenses of the applicant, and that the applicant has not made any other claims. the government, as we heard earlier, translated the judgment, so job done. They didn't have to do anything more. And that the violation is of isolated nature, so please close the examination. What happened is that luckily the Council of Ministers did not decide immediately on this matter, and we had time to actually interfere with Rule 9 statement. So we filed 3 such communications on April 2024, on June 2024, and on April 2025. The first thing we did, and I'm coming back to my introduction, is that we tried to tie the Miroslava Tudorova case with other previous cases, and actually cases that came out a little bit later. Of the European Court of Human Rights, basically trying to stress that this is not it's not just an isolated, that it is not only not an isolated case, but also it is connected to systematic issues of judiciary in Bulgaria, the position of chief prosecutor and their powers, and the issues with the Supreme Judicial Council. So we tied the case with the Penghezov and Kolevi case, and tried to reveal systematic problems and inform the court about 2 new domestic cases of abuse of disciplinary proceeding, although these cases were not brought by Supreme Judicial Council, but by the president of the respective court. Still, we used it as an example to show that this is still happening. In June 2024, we filed another Rule 9 communication and elaborated further on the public information indicating undue political influence over judiciary, and made a case for the need of comprehensive judicial reform. That it is not just the mere disciplinary procedure against judges that is an issue, but also the voice of judges in the Supreme Judicial Council. And in April 2025, again tying with the Kolevi case, we've stressed that changes in the Supreme Judicial Council were stalled. First of all, their term of office has expired for 2 years at that point. And second of all, some changes were supposed to happen in the law that did not progress at all. So what was achieved in June 2025, so this month, basically right before we came here, the Council of Ministers delivered a new decision which is based on our submissions. First of all, we are very happy that the examination is not closed, despite the government asking so. Second of all, Miroslava Tudorova is definitely not viewed as an isolated case. Council of Ministers notes the recent cases that I mentioned of judges also subjected to disciplinary proceedings, and invites the authorities to gather recent case law of the Supreme Administrative Court, examining allegations of ulterior purpose in disciplinary proceedings, specifically to examine whether administrative court bases their judgments on the European Convention of Human Rights. And last but not least, the Council of Ministers adopts our view on the systematic nature of the issues, especially in paragraph 2 of their decision. They call the government to renew their efforts to adopt reinforced institutional guarantees, like majority of members of the Supreme Judicial Council to be elected by their peers. So this is something that on first sight appears far-fetched based on the judgment of Miroslava Tudorova, but is actually connected, because this is the body that decides on disciplinary responsibility of judges, and in the end of the day, the majority of that body does not consist of judges elected by judges. And this is the end of it. I exceeded a little bit my 10 minutes.
Thank you very much, Radoslav. You did a very good job. This case is important because it demonstrates that while there is still a lot of way to go to achieve the substantial reforms we're aiming at, there was this quite immediate impact in that we have generated in placing the case high on the agenda of the Committee of Ministers. Compared to other cases and other similar problems in other jurisdictions, we passed quite fast from the situation of the authorities immediately calling for the closure of the case to the situation where it not only did it remain open, but it is examined under the enhanced procedure. Of course, the Article 18 element helped towards that direction. So another element to mention is perhaps this pressure that we can exercise through litigation, of course, when it is merited, through also arguing that Article 18 elements exist in the case, but also the real effect of the Committee of Ministers quite fast in this case. And the collective impact of the input of other bodies like the Venice Commission that through its opinions exercised further pressure, that not only managed to keep the case open, but managed to put the case in its right scope. The scope was there. It's just that it was not easy for us without this support of the institutions to demonstrate that this is indeed the case. So we have a lot of discussion, a lot to achieve still, but the case is at its right dimensions now. It is examined at its right dimensions. It has the spotlight that it deserves, and we're here to continue our good work. Thank you very much. We're passing on to Hungary now. Unlike Miroslava Todorova and the Bulgarian jurisdiction, the problem of harassment of the judiciary in Hungary dates way back in time. The case of Baka is one of the most long-standing such cases. We are all very well familiar because it has been included in the standard work of EIN together with your exquisite work at the Hungarian Helsinki Committee for very many years. And there have been, the trajectory was different than the Bulgarian one in ways that you will explain, dear Anna. The floor is yours.
Yes, I also believe, as you mentioned, that if we want to understand what's happening with judges' freedom of expression in Hungary, then there is no better way to start than to introduce the Baka versus Hungary case. Because Baka's case was not just a personal story of a judge, it was rather a warning. It was a warning what happens when a judge speaks up for rule of law and the state does everything it can to change the law to silence him. More than 9 years passed since the judgment of the European Court of Human Rights was made, and still nothing happened. Hungary did not implement this decision. There are still no legal protection for judges in Hungary, and they actually face very real risk if they do speak up. So in my presentation, firstly, I would look through the case of Baka, introducing the facts and the legal findings. Later on, what the Helsinki Committee has done about this specific case and the freedom of expression of judges, and also introducing the current situation in Hungary. So Mr. Baka was president of the Supreme Court from 2009. And then later on in 2010 and 11, there were new government-led judicial reforms. And Mr. Baka has spoken up, and he had criticism. But this criticism was rather judicial and not any political. And it was also necessary, but his views were not welcomed. And it resulted that Parliament restructured the court system, which meant that the Supreme Court was abolished and the Curia was established. This also meant that he could no longer fulfill his position, and his term ended 3.5 years earlier. And there was no legal remedy or no place to challenge this decision. So also he brought his case to Strasbourg. And in 2016, there was a ruling in his favor, stating that the Hungarian state has violated Article 6 and Article 10 of the Convention. Article 6, because Mr. Baka had no access to judgments and to challenge these decisions. And Article 10, because his dismissal was solely based on the fact that he had criticism. The judgment also highlighted that this Baka case had a chilling effect on other judges, saying a clear message to everyone in Hungary who is a judge that stay silent or you will be the next. The court also had a really clear message that the judges should be free to speak about issues affecting the justice system. And as I mentioned, this did not happen in Hungary yet, which means that there is still no legal protection for judges. There are no legal guarantees which would protect them for political dismissal, and the retaliation also continues. There is no hard law which would say in Hungary that judges can speak about legal issues, they can speak and comment on judicial independence, legal reforms, but there is an ethical code for judges which was created in 2022, and this actually clearly says that judges have this right so they can comment on issues related to judicial independence, legal reforms, and the court system. But this ethical code is a soft law, so this is not binding. And also, this is a recent development that the Curia president has challenged this ethical code, and the proceeding is still pending. And similar to Mr. Baka's case, I would like to highlight two other retaliation cases. The case of Judge András Kovács, who was suspended from his head of panel position, and the case of a scientific advisor who was dismissed with immediate effect. Both of them were dismissed by the Curia president, and based on the fact that they had criticism about judicial independence and the Curia. We can see now that these cases quite likely mirror the Baka case. And the retaliation didn't stop here, because in the end of last year, there were structural changes in the judicial system, or at least it was initiated, because there was a four-party agreement by the President of the Curia, President of the Judicial Council, and also the National Office for Judiciary, in cooperation with the government for the Ministry of Justice. And this agreement was problematic because it had vague reforms which would undermine judicial independence for exchange to get the long-awaited salary rise for judges. And surprisingly, this actually manifested in huge protest from judicial sides. So there was a street-based protest organized by a judicial association, and there were many public opinions published about the criticism regarding this reform. So now we can see that this was the first time in Hungary when judges actually organized such protest. And also Mr. Baka had a speech on here. And we might think that this means that there is no chilling effect in Hungary anymore, but I would like to prove otherwise.